Stop talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Drew Anthony, Karmelo Anthony's father, lost his appeal to get Sarah Field's defamation lawsuit thrown out. And a week later, his attorneys filed a 23-page first amended answer that takes a completely different strategic approach than trying to end the case early. Today, I'm walking through what's actually in it: the denials, the defenses, 28 special exceptions, and a counterclaim of its own. I'm Cassandra, and this is Legal Doc Talk. All right, y'all can see this on the screen. All right, let's get into it. So, before I start, quick correction to something people keep getting backwards online. Anthony's appeal was affirmed, but that's not good news for him. Affirmed means that the appellate court agreed with the trial court, which had already denied his motion to dismiss under the Texas Citizens Participation Act. So Anthony's attempt to get this lawsuit thrown out early before it goes any further failed. The case continues in trial court. That's actually the context for why this new filing exists. One, the Once that early exit option was off the table, his legal team had to pivot to actually answering the lawsuit on the merits, which is exactly what a first amended answer, affirmative defenses, special exceptions, and counterclaim does. Now, I'm not going to scroll through the whole, 23 pages, but I will read through it and post that in the members so that way they'll have that exclusive document. So if you haven't joined my membership, definitely join the Legal Eagle Squad membership so that way you can get actual court document readings. All right, so going back to this, the single idea that this 23-page document is organized around. The filing opens by pointing out that the appellate court itself recognized something important. Sarah Field's lawsuit accuses Anthony of two different categories of conduct. One, his own direct statements. Two, statements and conduct by co-defendant Tiffany Lynn McAdoo, aka Tiffany Billions, which plaintiff wants to pin on Anthony too through legal theories like agency, spokesperson status, acting in concert, and civil conspiracy. Anthony's whole strategy is to force a hard separation between those two categories, what he actually said and did, versus what someone else said and did that plaintiff wants to hold him responsible for. Right, y'all following me? All right. The answer opens with a general denial under Texas Rule of Civil Procedure 92, and I'll kind of scroll down so you guys can see that. All right, so here we go. Okay, I want to just make sure y'all can see that. All right, this is the standard boilerplate, denying everything and putting plaintiff to her burden of proof. Remember, if y'all been with me long enough, and some of you haven't. So anytime someone files a lawsuit, they bear the burden of proof. They are the ones who have to prove up their damages to the court. Okay? But then it gets specific. We're talking about the answer with a long list of individual denials that he defamed her, that he intentionally inflicted emotional distress, that he invaded her privacy, that he participated in any false report to law enforcement or CPS, that he participated in any swatting incident, that he doxed her or her family. And then it pivots directly to the agency theory. He denies that McAdoo was his agent, employee, representative, or spokesperson. He denies having any right to control the content, timing, or manner of her statements. He denies any agreement, conspiracy, or meeting of the minds with McAdoo, Charleston White, or several named groups, the disruptors, the advocates for the Anthony family, and someone using the pseudonym Chris Matters. This is all backed by a sworn affidavit from Anthony himself submitted with the filing, meaning these aren't just lawyer arguments. There's actually statements made under oath with real perjury exposure, if they are actually false. Okay? From there, the filing lists over 50 numbered affirmative defenses. That's generally a lot, even for this particular kind of case. And I'm going to scroll through it so y'all can see. That's the special denials. And here's the affirmative defenses. And I'm going to break them down, but I want y'all to see. I'm going to sum it up, but like I said, in members, you will have the full reading of this document. Whew. I would hate to be the paralegal drafting this. I'll tell you that. Alrighty. So, y'all saw that. First Amendment and Texas constitutional protection for speech on a matter of public concern. Truth and substantial truth. Opinion and rhetorical hyperboles. The argument that some statements simply aren't factual claims capable of being proven true or false. No actual malice. Qualified privilege for statements about a matter of shared interest, and a specific defense under Chapter 73 of the Texas Civil Practice and Remedies Code. It's called the Defamation Mitigation Act, arguing plaintiff never sent Anthony a proper request for correction or retraction before suing, which can limit certain categories of damages. There's also a detailed set of defenses specifically targeting the vicarious liability theory. No ratification, no civil conspiracy, no joint enterprise, no right to control. Each one chipping away at a different legal path plaintiff might use to connect McAdoo's conduct back to Drew Anthony. Okay. Uh, Now, this is the part I think is actually the most interesting strategically. Special exceptions are specific Texas procedural tools, basically a formal objection that a pleading isn't specific enough to let you actually prepare a defense. And Anthony's team files 28 of them. Y'all see? I hope y'all see. Here are the special exceptions. This amended answer is well put together, I must say. Shout out to, I was about to say the attorneys, the law firm, but I'm not. I don't want nobody calling them and harassing them. Woo, look at all these specialists. Ooh, good, googly muggly. All right. So that's the end of the special exceptions. So let's get back into that. The pattern across almost all 28 plaintiff's petition, according to this filing, uses group language, defendants collectively, without saying which specific defendant did which specific thing. So Anthony is asking the court to order plaintiff to replead with specific, specifics, real specifics, the exact words that were used, the exact date and platform, which statements are attributed to Anthony's, directly versus McAdoo, and critically, the specific factual basis for every agency or conspiracy claim. Not just the label spokesperson, but the actual date, manner, and words by which Anthony supposedly appointed McAdoo to that role. There's even a special exception aimed at one particular statement. Anthony reportedly said something like, time is going to tell, I promise you. Where the filing argues plaintiff never actually explained what false factual claim that statement is even supposed to represent. Why does this matter beyond just being picky about a pleading? Because if the court grants these exceptions, plaintiff has to go back and either commit to specific, provable claims against Anthony individually or drop the vague ones. That either sharpens the case against him or narrows it significantly. Right. Now, last piece. It's a generally aggressive move. Anthony isn't just defending, he's filed his own counterclaim under the Texas Uniform Declaratory Judgments Act, asking the court to formally declare, not just deny in this lawsuit, but rule as a law, that McAdoo was never his agent, that he had no legal right to control her statements, and he can't be held responsible for what she, Charleston White, or any of the named parties did or said. He's also asking the court to declare that any injunction against him has to comply with First Amendment limits and can't require him to police or suppress speech by third parties he has no legal control of. That's a meaningful, different posture than just denying allegations. Because normally, if we draft, like, if it's, and I don't want to say a basic lawsuit because each lawsuit is different. Each civil lawsuit is different when it comes to just the case itself, the situation itself. So sometimes what we do is, if we're responding to a lawsuit, it's just a general denial. But when you start adding special exceptions and affirmative defenses, then they're not coming to play. That's all I gotta say. But it's a different, posture. As I stated before, he's asking the court to put a stake in the ground on the legal relationship questions itself, which could matter well beyond just this one lawsuit if similar, claims come up again. So, as always, this is Anthony's own filing. And the plaintiff side of these agency and conspiracy allegations hasn't been tested yet. So whether the court grants these special exceptions and whether plaintiff has, repled with the specifics that's being demanded is generally an open question. No ruling has happened on this as of yet that I can see. I know that there's a lot of things that have been updated on a docket, and I am working on getting those, so I can update you guys on the latest thing that's happening. So once again, I'll be watching for any court rulings on these special exceptions and any new documents that come in. Okay, that would be the actual meaningful checkpoint here. So make sure that you are following me, you're subscribed, your notifications are on. If you are on Facebook or you are on Instagram or TikTok, come over here to YouTube, or you can go to my subscriber group on Facebook. And I also drop videos in the subscriber hub for individuals to watch. But drop a comment if you want me to cover, how special exceptions work in more depth. It's an underused tool that can generally reshape a case early on. All right. So I'm Cassandra, aka your favorite paralegal, and this is a Legal Doc Talk. Bye.